colleague Raghav Gupta. That is just in case I get stuck somewhere.
Okay, sir.
On the technical parts of it. Okay. I mean, don't knock him off if he comes. That's all.
Suraj ji, if you are available, this says this video is private, video unavailable.
It has started now. It has started.
Okay. I am muting the link. Can we start, sir?
Yeah.
A very good afternoon to one and all. Namaste. Welcome to the fourth lecture in the series of SCAORA examination conducted by the Supreme Court Advocates on Record Association. The topic that we are covering today is practice and procedure of Supreme Court. The paper is scheduled on 10th of June, and we have a very, very revered guest today. And the bio of today's guest reads as follows: lawyer and history buff with a sense of humor and rumor. We welcome you, Senior Advocate Sanjay Hegde, sir. Over to Aljo, sir, and it would be great if you can please introduce our guest for the day.
Thank you, Prakya. It is a great honor and prestige for this SCAORA to have Mr. Sanjay Hegde, Senior Advocate, as a chief guest and as a speaker on the topic practice and procedure. Sanjay Hegde, sir, before giving a formal introduction, sir was known as the permanent standing counsel for the state of Karnataka for me. So when I started my practice, we all see him as a person who is representing in all the cases for the Karnataka. Now I got an opportunity to read his bio. So his journey started in 1989 as a lawyer who joined the prestigious Mullah & Mullah in Mumbai. And later he shifted to Delhi and started practicing in Supreme Court. He was a standing counsel from 1996 onwards, and he was a union panel lawyer and senior arguing counsel for many years. In 2015, he was been designated as a senior advocate in Supreme Court. As such, we are actually enthusiastic and eager to listen to him in the courtroom as well as in the newsroom. His arguments always in the courtroom as newsroom always interesting. So he is a person who is a celebrity, as such a senior advocate who is well recognized in Supreme Court. Sir, we are thanking you for accepting our invitation today and your valuable suggestions to the young lawyers, those who are going to write the examination today, as well as those who are listening to you in the YouTube in the coming years, and also the students, those who are there in colleges, they are also keen to watch this YouTube live stream. So we welcome you, and we welcome all the students, all the audience today to hear Mr. Sanjay Hegde, Senior Advocate. Thank you, sir. And I am requesting you to, sir, you can start your lecture now.
Thank you, Aljo, for a very kind introduction. Thank you, Vipin, or not exactly thank you for pulling me into this practice and procedure lecture. See, the thing I was told when I was beginning, contemplating how to deliver this lecture, was that people often wanted tips from the lecturer about what was likely to come in the exam. I must confess that I am not the paper setter or anything like that. So it is unlikely that you will get anything with regard to what is likely to come in the paper. I would much rather start my or hope in this lecture to give you an overview of the subject, as well as to possibly tell you ways in which you can write the paper. Now, the first thing that I tell everyone, whoever is planning to write the Advocates on Record examination, is please stop using your computers. Please write everything by hand for the next whatever 2 weeks that you have till the exams begin. Because not many people realize it, but since we have just got on to dictations, we've got on to typing on on our laptops, we have actually forgotten the act of physically writing with pen and paper. Most of us. There are, however, many people who stick to the discipline of pen and paper, including people like Barack Obama, who all his great books he writes longhand. Now, the reason I tell you this is on a personal note. The first time that I wrote the Advocates on Record examination, I did not clear. I was one of those people who had one paper left. And the paper that I did not clear was drafting, was simply because I only wrote about 65 marks worth. And that was because I had not really practiced writing. And I just couldn't keep up with the paper. Now, having made those confessions, let me just try and share a screen, a PowerPoint presentation, which has been made with the help of my office associates. I am sorry if I am slightly okay. So the thing is, we can ignore the first part, and let me come to the next slide. Just a minute, please. We'll get to the next slide. Okay. Now, if there is anything that I would like to recommend out of the syllabus, it is this classic book. This book was written way back in the 1940s, and it has very many useful chapters which will stand you in very good stead throughout your career in the law. But it has very interesting chapters on handling even examination papers. And I'll just give you one sample where, I'm sorry, just 1 minute, please. I am trying to figure out how to reduce this screen, but if you don't mind, I'll also have this PowerPoint sent out later. So here Glanville Williams is describing how you solve question papers, and especially questions with problems. And the sample reads, I said that if the point of a problem is completely missed, the result may be catastrophic. This is true. But to give the wrong answer to a problem is not necessarily to miss the point of it. If the point is seen and well argued, the fact that the examiner does not agree with your conclusion will not seriously affect your marks. In legal matters, there's usually a certain room for difference of opinion. And even though there be positive authority against your view, the examiner is anxious not so much to test the details of your knowledge as to assess your ability to argue in a lawyer-like way. A safe course to adopt, if in any doubt, is to present the argument for both sides, to turn yourself successfully into counsel for the claimant, prosecutor, counsel for the defendant, and finally the judge. If the examiner disagrees with your judgment, it will hardly matter because you will have presented, even though you have also rejected the argument for the alternative point of view. So basically what Glanville Williams is here doing is to tell you that unlike maths, which is binary or physics, where you have only one answer, the field of law has nuances, sometimes more than one answer, and where you have argued both sides of the brief and then come to a conclusion, the examiner is still able to give you a few marks where otherwise nothing could have been given. If you just excuse me for 1 minute, I'm trying to get to to the next part of the presentation, and since the previous one was obstructed when it went into full view, I will try another format, please. Just 1 minute. Okay. The next book that I would greatly recommend is give me a minute, please. I'm sorry. Is the Supreme Court manual. The Supreme Court manual is has been brought out from 2013 onwards. It has its handbook. It's available online, and this is the basic Bible, along with the Supreme Court rules, both of which form the foundation of Supreme Court practice and procedure. Now, the manual, especially chapter 2 of the handbook, sets out the Supreme Court's various jurisdictions. And let's spend some time on each of them. Now, the Supreme Court's jurisdictions are appellate, original, advisory, and its own inherent jurisdiction. Now, in its appellate jurisdiction, you have your normal appeals under Articles 132, 33, and 34. You have the special leave to appeal under Article 136, as well as statutory appeals. As in its original jurisdiction, the Supreme Court has its writs under Article 32, its suits under Article 131, the transfer petitions under 139, election disputes, and it also has its advisory jurisdiction under Article 143. You have in its inherent jurisdiction, the Supreme Court's inherent power to review its own judgments. You have the power of the Supreme Court to hear curative petitions, which it has come up with as an innovation itself through its rules. And you also have the Supreme Court's power of contempt. Now let's examine each of these jurisdictions in turn. Just give me 1 minute, please. Okay. So you have the Supreme Court's appellate jurisdictions under 132, 133, and 134 of the Constitution of India, read with orders 19 and 20 of the Supreme Court rules. Now, these are in the course of a lifetime in practice. We very rarely come across appeals which are so certified under these articles. We are all, in the words of Mr. R.N. Trivedi, the late R.N. Trivedi, who was Additional Solicitor General, we are all 136 ke aulad, that is creatures of 136. We've so got used to Article 136 that we forget sometimes that appeals to the Supreme Court under other articles of the Constitution are also possible. Now, Article 132 pertains to appeals where a high court grants a certificate that a case involves a substantial question of law as to an interpretation of the Constitution of India. Now, this is more or less a historical relic because it came in the early days of the country as well as the court. And when you had various high courts and you had a newly formed constitution, then the interpretation of the constitution, if it arose before a high court and the high court decided one way, but it still had doubts, it could then give a certificate to appeal. Where this is in line with Article 133, which pertains to civil appeals, where a high court may certify that a case involves a substantial question of law of general importance. Now, this has been defined in the judgment that is cited here, that is ITC and other judgments, that the High Court is required to consider whether a substantial question of law of the kind mentioned is made out. And even if such a question is made out, the certificate must be granted. Once a certificate is granted, all grounds can be raised in appeal before the Supreme Court. So this is consistent with Supreme Court practice and procedure that once a Supreme Court takes on an appeal, maybe on some point or the other, it does not necessarily confine itself only to that point. It goes into all questions of fact and law, and then can decide on that basis that the point itself doesn't arise, or it can decide that the point was not properly answered in the court in the various high courts, and that the Supreme Court gives the authoritative version. Now, Article 134, if you just give me a minute, please. Sorry. Article 134 relates to criminal matters, where Article 134(1)(a) grants a right to appeal to a person who has been convicted by a high court and sentenced to death following an acquittal by a trial court. Article 134(1)(b) grants a right of appeal to a person tried and convicted and sentenced to death by a high court. But trials in a high court now no longer take place. Under Article 134(1)(c), a high court may also grant a certificate that a criminal case is fit for appeal to the Supreme Court. Now, having done these appeals that rise, if I could then go to our normal 136, which is necessarily a discretionary jurisdiction, and it can be filed against any judgment or decree or sentence or order of any high court or tribunal in India. It's a plenary power, but the court has generally put its own limitations on when it will interfere. It adheres to certain basic principles, including whether a question of law is involved, whether a substantial miscarriage of justice has taken place, and whether the High Court or tribunal has passed a speaking order. In Rafiq, it was held that the Supreme Court's special jurisdiction under 136 is meant mainly to correct manifest injustice or errors or of law of great moment. In Suryakala, which is a 2007 case, the Supreme Court said that 136 is not a regular forum of appeal and is a residual provision to be used at the discretion of the court. Now, 136 actually owes itself to what existed in pre-independence days, when you had an appeal to the Privy Council, where the Privy Council sitting in London could hear cases on appeal from the Indian courts, provided the Lords of the Privy Council gave leave to appeal. Most often, the Lords of the Privy Council just had a standard order and a card, which they said that they would read out and say, we will advise His Majesty that nothing further needs to be done in this matter. So it is said that councils, while arguing in the Privy Council, were always watchful about whether the judges were or the Privy Councillors were heading going towards the card or not, and arguments at that stage started getting more and more feverish to try and prevent a dismissal. It's somewhat similar to what we see in our courts even today under 136. Now, 136, it comes in to the Supreme Court primarily out of shifting the Privy Council appeals back to the Supreme Court of a newly independent nation. And in those days, of the early days of the Supreme Court, very rarely were appeals filed from the high courts. In an era of the internet, in an era of plane travel, it is difficult to imagine how remote even Delhi looked to people, especially from South India, when they came to challenge what would otherwise have been final in their states. And Vipin, who comes from a tradition of whose father was among the early practitioners in this court, could possibly tell you stories that I've heard where when people came to file one special leave petition, and it was pointed out that no, there were actually the judgment dealt with 5 appeals. So please file 5 petitions so that there is enough work in this court. That was what the early days of the court were like. These kind of recollections can come only from the old timers, most of whom are no longer around. This was a story that I had heard from Mrs. Shamla Pappu, whose father, Mr. Murthy, was the legendary first registrar of the court, and to whom we owe most of the crafting of the Supreme Court rules, and which have then been updated from time to time, depending on the needs and exigencies of the day. If I can move to the next slide. Just a minute, please. Sorry. Yes. Now, we also have in the Supreme Court statutory appeals. Appeals under various statutes, such as Section 66 of the Consumer Protection Act against orders of the National Consumer Disputes Redressal Commission. You also have appeals from the NCLAT, and you also have appeals under the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act, where the Act provides for a right of appeal to persons who were convicted in an appeal by the High Court after an acquittal in the trial court, and sentenced to life imprisonment or of imprisonment up to 10 years. In Chetia versus Bhuiyan of 2005, while dealing with a statutory appeal under the Representation of People's Act, the Supreme Court held that it has an inherent power to summarily dismiss a first appeal, even though statutory in nature. It was, however, clarified that this power should be exercised only by way of exception. Now, what does this mean? The normal rule is that every civilized society must have at least one appeal. There are many tribunals where the tribunal's decision is often final except for an appeal which is provided by statute directly to the Supreme Court. Now, if it is an appeal, should it not be fully heard? Should it not be heard on fact and law, the manner that any appeal is heard after special leave is granted? The Supreme Court says no. We will try and hear statutory appeals fully, but we also have the power to dismiss them summarily, where we are satisfied that there is in fact no question of either law or fact which requires the Supreme Court's interference. Though it has been said that this power to dismiss is to be exercised only by way of an exception, the Supreme Court normally treats the statutory appeals in the same way that it treats petitions under 136. It has to be satisfied that the appeal has such a substantial question of law or there is such gross injustice that it should be heard fully. Moving on to the next slide. We now move on to the original jurisdiction of the Supreme Court. We have, after 136, the article of the Constitution which advocates on record most often resort to are writ petitions under Article 32. The Article 32 itself is a fundamental right, and the founding fathers, and especially Dr. Ambedkar, thought that it was the very soul of the Constitution. It was to the mind of the founding fathers of the Constitution something which was so fundamental that anybody, any citizen of India could approach the Supreme Court directly and seek any of the writs if there was a question of a violation of a fundamental right. So this one of the leading cases out here is the Fertilizer Kamgar Union case in 81. And by virtue of Article 32, the court can issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, 32 got quite a big expansion once public interest litigation started in the court in the 1980s, in the post-emergency era, when the court said that it would widen the scope of public interest litigation. It would reduce the requirements of locus standi and entertain petitions on behalf of the lost, the last, and the least, to use Justice Krishna Iyer's words, so that people who could not approach the court themselves for financial or other causes could also be represented by people who were genuinely concerned. One of the lead cases is Bandhwa Mukti Morcha, where it was held that Article 32 confers the widest amplitude of power on the Supreme Court to grant relief, and there's no specific indication circumscribing the power. Thus, PILs can be filed by any member of the public acting pro bona fide for relief in cases where such fundamental rights stand violated. After 132, we come to Article 131, which is also part of the original jurisdiction of the court. The court sits to decide suits between two states or between state and center. Often the Supreme Court is the arbiter of disputes that arise within the Union of India, within the Federation of India, and is an inherent part of the federal structure. That if two states have a problem inter se of a legal nature, or they have a problem with the Union of India, which court can decide? If you'll excuse me for a minute. Now, the conditions required to be met to invoke the Supreme Court's jurisdiction under Article 131 are that the dispute must be among states and or center, and the dispute must revolve around a question of law or fact of a legal right. It's been invoked several times. In recent history, the state of Kerala filed a suit against the Union of India challenging the CAA. The states of Kerala, Tamil Nadu, Karnataka have separately come in suits saying that money which was due to them under various accounts had not been paid and have asked for the Supreme Court's intervention. The Supreme Court has, in some cases, made certain directions. I remember Standing Council of Karnataka filing a suit on behalf of the state of Karnataka, where, or rather, defending a suit on behalf of the state of Karnataka, where the state of Maharashtra laid claim to the city of Belgaum and other surrounding areas on the ground that they were Marathi speaking. That suit is still pending. One of the earlier suits was, which is mentioned here, Karnataka versus Union of India, was when the Grover Commission was appointed by the then Janata government to probe into certain acts of the Chief Minister of Karnataka. And there, the court held that Article 131 is a self-contained code on matters falling within its purview, and the sole condition for invoking this jurisdiction is that disputes must exist between parties, must involve a question on which the existence or extent of a legal right depends. The transfer petitions, and this is an avenue which provides a lot of work to the two advocates on record of the Supreme Court. Transfer petitions come not only in matrimonial matters, which seems to be the most used circumstance in which transfers are sought, but transfers, Article 139A was added to the Constitution by way of the 42nd Constitutional Amendment to avoid multiplicity of litigation. Article 139A1, read with Order 40 of the Court of the Rules, relates to transfer of cases involving the same or substantial questions of law pending before the Supreme Court and one or more high courts, or before two or more high courts. The idea simply being that instead of two judgments from two high courts or two or more judgments from two or more high courts, it is better that a question of law, a common question of law pending in various high courts is decided by the Supreme Court itself. This is resorted to more by governments, and especially the union government, because the legislation, especially union legislation, tends to be challenged in different courts, and very often different courts have had varying judgments. Article 139A2, read with Order 41, pertains to transfer of case pending before a high court to another high court. 25 of the CPC and 406 of the CRPC pertain to transfer of a suit or appeal or a case or any other proceeding from a civil criminal court or high court in one state to a civil criminal court or high court in another state. For the exercise of jurisdiction under 25 of the CPC, The only relevant consideration is expediency for the ends of justice. Under 406 CRPC, the relevant factors for consideration, including reasonable apprehension of miscarriage of justice, likelihood of bias, attitude of public prosecutors. So the Section 25 CPC transfers are mainly these matrimonial matters. Under 406, sometimes cases like the Best Bakery case during the Gujarat disturbances, which got transferred for trial to Bombay, and others, or the Bilkis Banu case. That's where the Supreme Court has exercised its power to transfer cases. If I can, then just 1 second, please. Then comes election disputes and election petitions involving disputes to the election of the president or the vice president shall be decided by the Supreme Court. That's under Article 71(1) of the Constitution. And it's dealt with in Order 46 of the Supreme Court rules. And the Supreme Court has adjudicated quite a few election petitions, including Charan Lal Sahu versus Fakhruddin Ali Ahmed, Charan Lal Sahu versus Neelam Sanjeeva Reddy. And Mr. Charan Lal Sahu was also an advocate on record whose children still practice in the Supreme Court. He had a long and distinguished career, not only as a lawyer, but as a frequent fighter of elections. So, I must also recollect an instance where in an election dispute, where the then President of India, V.V. Giri, I believe, actually came as a witness when election dispute regarding his election was filed in the Supreme Court. Then we have the advisory jurisdiction of the Supreme Court under Article 143 of the Constitution, which provides for a presidential reference to the Supreme Court to decide a question of law or fact that has arisen, which is of great public importance. An advisory opinion of the court has been held to hold great weight and high persuasive value on all courts in India. That's the judgment in regard to the Special Courts Bill. The Special Courts Bill in 1978 was a presidential reference to decide on whether special courts could be formed for the trial of excesses during the emergency. The Supreme Court did give its reference, but give its answer on the reference, but the Supreme Court is not bound to answer all and every reference. For instance, in the presidential reference on Ayodhya, that is shortly after the demolition of the structure in Ayodhya, of the disputed structure in Ayodhya, the president, which is essentially the union government, made a reference to the court asking whether it would come to whether it could answer whether any temple had at that point had been at the site of what was the mosque. The court declined to answer that reference, saying that it was not necessary. It gave its own reasoning as far as the other provisions of the Places of Worship Act and other enactments with regard to the Ayodhya dispute were concerned. But I remember a phrase from Justice Barucha's judgment, where he said that Ayodhya is a passing storm. The honor and dignity of the Supreme Court cannot be compromised for it. Well, sometimes there are words in a judgment which may then be remembered by few, but people who constantly comment on the courts And answers which are sought at any particular point of time, if they are not delivered in time, sometimes the questions come back to haunt the court. Sometimes the reverse also happens. When the court has answered something and you're not satisfied with the answer, governments have tried to resort to Article 143. A case in point was the 2G judgments. After the 2G judgments, which set aside the allocation of 2G spectrum and cancelled the contracts, the then government came back with a reference asking whether any public resources could only be auctioned and could not be dealt with in any other manner. And the Supreme Court, while answering it, gave certain exceptions which have now formed the basis of the law. So though an answer to a presidential reference is not stricto sensu a judgment, it still has high persuasive value. Now we come to the inherent and plenary jurisdiction of the Supreme Court. That is when you go to review petitions, the Supreme Court has all the power to review its own judgment or any order which it has pronounced. The rules provide, Order 47 provides that a review petition must be filed within 30 days from the delivery of the certified copy of the judgment or order sought to be reviewed. That the review is under Order 47, somewhat like the review provisions of the CPC, that the jurisdiction is limited where there is a glaring omission or a patent mistake or where a grave error has crept into the judgment. And the mere fact that there is some other judgment which says something else is not necessarily a ground for the review. Now, the Supreme Court has created, under its own inherent and plenary jurisdiction, curative petitions. Curative petitions came about primarily when the Supreme Court rules itself provide that after a review has been dismissed, there cannot be a second review. But despite the fact that a matter has gone through the court process, has had a judgment of the court, and the same court has reviewed the judgment and found no error, yet there are situations where something has occurred later which would cast a shadow or a doubt upon the original judgment. So then the Supreme Court created a solution in the Rupa Ashok Khurra case, which was a matrimonial matter, but where the settlement, with regard to the settlement, there were certain doubts. So the court, they said that it would entertain a curative petition if a senior counsel or a senior advocate certified that there were that two major grounds existed. One was where, due to some defect of procedure or otherwise, a party was not heard. The second was where the court was disabled due to some cause from hearing that matter. For instance, in the old classic case of the Grand Canal Junction Company, there was a Lord Chancellor who had a share in the company and yet heard the case. That case was set aside by a subsequent judgment. That judgment was set aside by a subsequent judgment. So something like that, where if due to some fault in the court itself, and if it was so certified by a certificate given by a senior counsel, then the Supreme Court would look at the original judgment or take a relook at the original judgment in a curative petition. So, if there is one bit of practice and procedure, practical aspect of practice and procedure is that there are senior counsels and senior counsels. Some do certify curative petitions, some do not certify any. And those who do not certify any often point out to the two requirements under Rupa Ashok Hurra. Now, the two straight lines which Rupa Ashok Hurra drew have been muddied a bit recently in the recent judgment in DMRC, where the court has stated that it extends to cases where a court acts beyond its jurisdiction, resulting in a grave miscarriage of justice. So, at this stage, if we go back to that early passage that I showed you from Glanville-Williams, it does seem to me that as far as curative petitions are concerned, there can be more than one answer. And unless the court again speaks as to what are the kind of situations that the DMRC case envisages, I suspect that there will be more and more people who will be willing to certify curative petitions. Contempt petitions, of course, go with any court of record, and the Supreme Court obviously has powers of contempt. In addition to powers of contempt, it also has powers which require all authorities to come to the aid of the court, all civil authorities to come to the aid of the court. One of the leading cases has happened recently in Prashant Bhushan's case, that the constitutional power of the Supreme Court is independent and is not limited by the provisions under the Contempt of Courts Act. There are rules to regulate the proceedings for the contempt of the Supreme Court, which establishes the legal framework to govern contempt proceedings. Now, having gone through the various jurisdictions of the court, let me quickly go through the duties of advocates. The advocate has a twofold duty: to protect the interest of his client and pursue the case briefed to him with the best of his ability, and as an officer of the court. What does the phrase "as an officer of the court" mean? The officer of the court phrase means that the court also acts through the advocates, and that we, both bar and bench, are part of the same justice delivery system. And if an advocate in any manner to take an unfair advantage misleads the court on fact or on law, then he is not doing his duty either by his client or by the court. The duties of the advocate towards the court include respecting the court, acting in a dignified manner, maintaining propriety in conduct, a refusal to represent clients who insist on unfair means, and to adhere to the proper dress code. Duties towards the client include full disclosure about connection to any of the opposite parties, to uphold the interest of the client, to not disclose privileged communication with the client, do not appear in matters where the advocate is a witness. Now, each of these would require very many chapters to, very many minutes to go through. But essentially, I would sum it up by saying that you are in a constant state of peer review. It is people who are your peers in court as fellow lawyers who will constantly be checking that you maintain the highest standards of professional conduct. Even the judges who check you are, in a sense, your peers. They are lawyers like you and me, but who have gone on to the other side of the bar and who are handling the legal process from that side. So when you take a shortcut or you take something which is strictly not done as per the rules of the game, then you are essentially asking for your peers to judge you, and they do not necessarily judge you kindly. Now, the duties, in addition to the duties of an advocate, there are duties of an advocate on record, which have also been commented on in a few judgments, if you'll excuse me. The responsibilities of an AOR and the possible misconducts are enlisted in Order 4, Rule 7 and Rule 10. The court in Rameshwar Prasad Goel said that the court conducts an examination before enrolling a person as an AOR, and the basic purpose of the examination is to verify whether the person is well versed with the rules, practice, and procedure of the court, and to test his legal acumen and ethics. He must be fully acquainted with the drafting of proceedings as well as its manner of filing in the registry. An AOR is not beneficial only to the court, but also assists in the working of the registry. In such a fact situation, an AOR cannot lend his signatures just to camouflage the requirement of rules. He, in addition to doing the work of drafting, filing, appearance, and assisting the court, must maintain professional ethics and proper standards so that the court may rely upon him without any reservation. That is the crucial phrase, rely upon him without any reservation. I would request my younger friends always to maintain the highest standards, and being an AOR is being a trustee of your client's cause before the court, but the court in turn also has trusted you with handling the client's cause in a manner consistent with the highest traditions of the Supreme Court. Now, the court has on various occasions deprecated the practice of AORs merely signing. The court has lamented that if AOR merely lends his name to file a case without ensuring whether the petition is drafted in adherence to the rules or without being responsible for the conduct of a case, the very purpose of the system of AOR stands defeated. In the case of a state, Punjab versus Ashok Singh Acha, the court emphasized that the importance of the preparation of the synopsis and list of dates and attention in compliance with the Supreme Court rules. So, and the last thing that I would request is that we all see in Suits and various other things, various other movies, that you have fiery advocacy, but fiery advocacy is not necessarily going beyond a particular point. Justice Sawant said it right in a case called Vinay Chandra Mishra, who was formerly president of the Bar Council of India itself. Said brazenness is not outspokenness, arrogance is not fearlessness, use of intemperate language is not assertion of right nor a threat, an argument. Humility is not servility, and courtesy and politeness are not like lack of dignity. Self-restraint and respectful attitude towards the court, presentation of correct facts and law with a balanced mind and without overstatement, suppression, distortion, or embellishments are requisites of good advocacy. A lawyer has to be a gentleman first, or a gentlewoman. His or her most valuable asset is the respect and goodwill he enjoys among his colleagues and in court. This is what we aim for. This is what brings us credibility. And this is what we look forward to in Advocates on Record. Before I go, I must tell you that I myself have been an advocate on record. And in our days, there used to be only about 4 or 5 people or less than 10 people who would pass the examinations. And the person with whom I trained as an advocate on record, the late Mr. Shrikant Deshpande, father of Shishir Deshpande, once told me that after he had passed the exams and the chamber summons was filed before the judge was Justice D.P. Madhan. Justice D.P. Madhan was a Parsi from Bombay. He had a sense of humor. He looked at all of the prospective advocates on record and said, have you found a good clerk? Are you happy with him? When everybody said yes, 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 and he said, go become an advocate on record. So the point I wish to make is that we work, but along with us, as advocates on record, our clerks, our associates, all our family, and I take this opportunity to thank my office, my clerks, my associates. I thank specifically Stuti Srivastava, who helped put together this presentation, and Raghav Gupta, who's helped me with trying to present it. There have been a few glitches. The glitches are all mine. I hope you've gained something from this presentation, and I'm ready for questions. Thank you very much.
Thank you so very much, sir, for such a riveting and compelling session. I was totally glued to the lecture, personally speaking. And I know despite regular coughs, you were able to take the lecture along with. In fact, the PPT has also come very handy, and we would request if we can get the copy of the PPT, we would be circulating it in the group. The videos will be uploaded on YouTube shortly. So we just have a brief question. We have a very specific question that has been asked in the chat box. I'll read it to you. It says, sir, can you please tell us if review and curative petitions are filed under inherent or original jurisdiction? As per SCR review and curative petition, it is stated to be under the original jurisdiction.
Well, review petitions are part of the inherent power of the court. So it's not an original jurisdiction in that sense. Original jurisdiction is that which is conferred specifically by statute, or in this case by the Constitution. The Constitution envisaged that you would have these various jurisdictions under the appeal provisions, 132 onwards, or the writ petitions under 32. So I would think that review petitions and curative petitions, which flow from review petitions, would fall from the inherent powers of the court and not from any original powers. All right. The Supreme Court is a court of record, and all courts of record have inherent powers.
Very well, sir. Thank you so much. With that, we come to an end of the lecture series. I'd humbly request our Honorable President, Mr. Vipin Nair, sir, to kindly give a vote of thanks. Thank you very much, sir. It was an honor hosting you.
Thank you.
Sanjay, it was an absolute treat. And the pains which you and your office has taken for the PowerPoint is amazing. So we will be requesting you to share it later whenever it's ready. One small thing, this man so humble in front of us, Sanjay, he's got a 1 lakh plus follower on the Twitter. And we rate him as a moral conscience keeper of Supreme Court. You know, he takes up issues, maybe the Northeast or anywhere, he's first man to go. And one more thing, I was talking to most of his juniors. He's actually given rent-free accommodation for his juniors while mentoring them as AORs. It's absolutely amazing. And we look forward to closely associate you with this SCAORA team on different aspects. And I've seen that you're not writing much in papers now. Otherwise, your cutting-edge articles in Hindu and Indian Express used to always thrill us. But on behalf of SCAORA, it was an absolute treat to hear you. And thank you for taking out time for us. Thank you so much.
Thank you, Vipin. Thank you, Nikhil, and everyone. Sorry, I can't. Again, my screen seems to have gone blank for a minute. It was a pleasure, and I'm sorry about my throat. It seems to be acting up currently.
Please
Thank you very much.
Thank you so much.
Thank you.
Thank you, sir.
Thank you.